In the case of Walt Disney World versus DeSantis, much ado has been made about the First Amendment claim. In fact, the First Amendment claim is really the only one people talk about out of the 5 causes of action filed by Disney. Now, that may be because all of the causes of action are complete trash, or because people actually don't understand the area of law, because most people who claim to be experts on this actually do not know Florida law. They don't know Florida real property law, and they certainly do not know about special districts in the state of Florida. Of course, myself, Andrew Esquire, over here at The Legal Mindset, I actually practice in this area. This is my specific area of practice. So really, I haven't met anybody who's putting out information out there who knows what they're talking about. Everybody is from out of state. They don't know Florida at all, and they have no idea about the relevant statutes in this issue, things that I've dealt with day to day for years. So I'm going to get into it and get into how today Disney is stuck in a rock and a hard place. They are stuck between having standing on the First Amendment issue, possibly, but also having committed securities fraud and being guilty of securities fraud, or having no standing on the First Amendment issues at all whatsoever. And we're going to get into that choice today, because that's something I'm really not hearing as much about. And I think everybody should be talking about this, is that Disney has to choose. Are they guilty of a crime? And well, maybe there's a First Amendment claim, right? They might pass standing. Now, that doesn't mean they actually have a claim. This means, hey, maybe they have standing, or they don't have standing at all. Now, what do I mean here? Now, the issue is that many of the claims which are here in this claim that Disney has filed are related to other things, such as contract clause, takings, due process. But the two that people are talking about on the internet are the 4th and 5th cause of action, the First Amendment violations. Now, in these two specific violations, these First Amendment violations, what they claim is that Ron DeSantis retaliated against Disney itself, the Walt Disney World Corporation, for its political views. Of course, this is absolutely wrong. In fact, Ron DeSantis really did nothing here specifically. The Florida legislature as a whole, right, which is made of many people, right, many individuals, voted to repeal all special districts that are formed before a certain time, which happened to hit Reedy Creek. Now, Reedy Creek is not Disney World. Reedy Creek is a special district within which contains Walt Disney. It is not Walt Disney World as an entity. It is not an affiliated entity. It is supposed to be an entirely different entity. Now, Walt Disney itself, in its own complaint, in this very complaint here, and as well as in its bond disclosures, states that Walt Disney does not encompass all of Reedy Creek. In fact, it's only in the 70s in terms of percent. I think it's 72% of the total land ownership within the district. So that means by proxy, there's 38% that is owned by other entities. In fact, there's a number of other entities that own property within Reedy Creek, within the Reedy Creek Improvement District. Disney is simply the majority owner. And this would be the same as if, for example, you lived in a town that maybe had a very large ranching operation. There could be a ranch that takes up 70% of the municipal boundaries of your small town. Does that mean they control your town? Well, they may have heavy influence. They may be a significant stakeholder. But if somebody sued the town, are they suing the individual company, the ranch? No, they're not. Right? No, they are not. Those are two distinct things. And when I convert this example over to a city or town, you could probably understand this a little bit more. Even if a business is significant in a town, even if it's significant in a city, that does not make it the same as the city. Maybe they're one and the same, right? Maybe when you think of Starbucks, you think of Seattle, right? Maybe you think of Atlanta when you think of Coca-Cola. Who knows? But that doesn't mean when you sue Atlanta, you sue Coca-Cola. No, quite different in terms of the entities. And a special district, the Reedy Creek Special District, it is a form of government. Yes, it's lower than a city or county. It has less powers, much more limited powers, but it is a separate entity. So in order to prove these First Amendment claims, they have to prove that Disney was damaged directly, that Disney itself was damaged. And in fact, there's nothing that Ron DeSantis himself did that actually damaged Disney directly, at least initially. So he disbanded Reedy Creek. He formed this new Central Florida Tourism Oversight District, this new district. Disney doesn't challenge that. Disney doesn't challenge any of that. And those are the actions by Ron DeSantis. The only thing that Disney can possibly say, hey, maybe there's something here, is later on. What happened is right before the district transitioned from being Reedy Creek and Reedy Creek going away to the Central Florida Tourism Oversight District. Right before that happened, they passed in the last minute these developer agreements and these restrictive covenants. And as part of that, they entered into an agreement, supposedly, right? There's a big question of whether these are actually valid agreements. So they tried to enter an agreement between Walt Disney World and Disney. And what that did was, to make things very, very simple, is they gave Disney the right to control certain development credits. They also gave Disney the right to control their aesthetics on their government buildings. Now, those aesthetics provisions, those probably aren't enforceable under Florida law. But what Disney would argue is, by voiding those development agreements, well, that may have given them some standing on the First Amendment issue. The problem there is that Ron DeSantis didn't do any of that. The people who voided it, the voiding was done by the district itself. The district itself is the proper party here. If they want to sue, it's not really Ron DeSantis, it would be the district itself. And there's been something they've been holding back on. And one reason why, even in this complaint, if you look at this complaint, they don't sue the district. And folks who have been watching my channel will know it's because of the bonds. The bonds are the thing that people do not talk about, that nobody knows about, and that, frankly, most people are uneducated on, because they don't do public finance. They didn't do this. They don't know about this. So what they're afraid of is, they are afraid of these bonds being called. So if there's anything that would jeopardize these bonds, these almost $1 billion in bonds, they can be called. And those bonds, they can come due. And what they will do is this: they don't spread them to the state of Florida. Oh, no, no, no. You only need to look at the neighboring communities, such as the community of Reunion. What they did in that neighboring community, and what they would certainly do here, is go after the property. Yes, they are allowed to actually go after property within the district. Now, if the district wants to try to collect that money from Disney, they'll turn around to Disney and say, hey, we need $1 billion. And we're going to put a lien on your property for $1 billion. And if Disney cannot pay that up, well, guess what? The Magic Kingdom would be auctioned off. The Magic Kingdom will be sold to the highest bidder to satisfy that $1 billion. And that would just be the way it goes. And they would be paid up through their land being taken, through their cash cow going out from the middle of their fingers, poof, just like pixie dust. But why do I say securities fraud? Well, here's the thing. They want to argue that the district is Disney. They want to argue that the district and Disney are one and the same, and that because they're a majority owner, well, that gives them a clear interest because they're a majority owner, right? Well, here's the thing. As part of the bonds that are issued along with this, which you can find here pretty easily on EMMA, which is the Electronic Municipal Market Access System, you can pull up the Reedy Creek bonds. There's actually several series of bonds. Right now, I'm looking at the Series 2018. But if you want to go to the issuer homepage here, you can just check out and see. They've actually issued a lot of bonds. In fact, you can see here, they've got utility revenue bonds. They've got some other series, refunding series, some Series 1 here, and a bunch of series going back to 1999, which are still being paid off. And these are all payable by Reedy Creek and solely by Reedy Creek. So as part of all of these bond issuances, they had to give assurances. And one of the assurances they had to give was that Reedy Creek was a public and independent agency, that they were totally independent, that they were separate. They were not an alter ego of Disney. If they are, these bonds would be invalid. These would be illegal bonds. This would be a securities fraud for them saying, hey, these are public bonds, and they are not. And here's the whopper. Here's the real whopper. Guess who gave the certifications that Reedy Creek was indeed public and separate from Disney? That's right. If you go back and you pull up the certifications, you see that they relied upon the opinion of Mr. John M. McGowan, special counsel to the district, regarding the representations of the various parties, including the representations of the public officials, the representation of the government. So John McGowan was working as special counsel for Reedy Creek District. Understand this very quick. John McGowan, who is that? Who is this gentleman? He is the chief counsel at Walt Disney World. the chief counsel. He is their top lawyer. For 30 years, he's been their chief counsel, John M. McGowan, but he's the one who was working for the district certifying it's public. This is why Disney is in hot water, and they are stuck in a situation where if they continue pushing this line that the district is Disney, well, I think they're really at risk of securities fraud, all of them, including John McGowan, who certified this himself, to look into these certifications and say, John, you made a certification that this is a public entity, when in fact you knew this was actually an alter ego of Disney. You were operating a public entity for a private purpose. You were operating it with the same officers, attorneys, staff members as the corporation, and it was merely a shell, much akin to the Village's decision up there, where they found that, hey, this is just an alter ego. This government's just an alter ego. It's actually a corporation, never going to turn over. Under a tax analysis, under a bond analysis, this is highly problematic. Now, this is also why Disney treaded lightly when it comes to the Central Florida Tourism Oversight District, because they know that if they were to cause that district to go away, to disappear, they know that Magic Kingdom, Epcot, Animal Kingdom, Wild World of Sports, all of those would have liens placed on their property for almost $1 billion in unpaid bond debt. How about those apples? And this is something that nobody is talking about because nobody knows this law. Nobody knows how this works. But of course, here in the Legal Mindset, this is my zone. So I'm going to continue to spit facts for you guys and continue to talk about this more and more and more. If you like this type of content, smash the like button, leave a comment. Talk to you later. Peace.